Hello and welcome back once again to the Appellate Practice and Procedure course at Solo Practice University. I'm Todd Smith and I'm the instructor for this course, as you probably know by now. We're here today for class number 3 in our series, and it is entitled Handling an Appeal, the Decision to Appeal in Preliminary Matters. So without further ado, let's get started. This is the first of a series of 4 classes that focuses on handling an appeal. We've kind of dealt with other issues leading up until this point, and now we're starting to get into the details of and the mechanics of handling an appeal. So as far as the first slide is concerned, we have an overview of the topics that we're going to cover today. The first is helping the client decide whether to appeal, and some of the factors to be considered in there are cost, the likelihood of success, and ethical and other issues that may arise. And then as far as matters preliminary to the appeal, we're going to talk about jurisdictional issues, such as what kind of appeal you're going to attempt to bring, the actual notice of appeal, the timetables that may be in play and how you want to manage those, and docketing the appeal in the appellate court, and then of course the appellate record. You may have noticed that the backdrop is different for my video today. I'm doing this sort of on the fly, and I don't have the PowerPoint presentation in front of me, although I do have a printout of the slides, so you may hear me shuffling paper more than you usually do. And so I appreciate your patience in that area. Let's talk about first the decision to appeal. Usually this comes up, and moving to the next slide with that title on it, this comes up in a couple of different scenarios in which you may have been hired to work on an appeal. The first is that the client has decided that it wants to appeal, or he or she wants to appeal, and they've decided to hire you. Or secondly, the client is unsure about whether to appeal and needs help in deciding whether to make that jump to actually prosecuting an appeal. And when I say client here, we could be talking about trial counsel just as easily as a client. In fact, a lot of appellate lawyers, as I've discussed in previous presentations, do deal largely with trial lawyers, myself included, because they are a good source of business. So whenever I use client in this presentation, you could just as easily substitute trial counsel for that term. So the setup is basically that you've been approached about working on an appeal, potentially prosecuting an appeal for a client or on behalf of a client, and what are the next steps? How do you go about the initial mechanics of pursuing an appeal? The client's first question, if you move to the next slide, is almost always going to be, what's it going to cost me? In this day and age, it's especially true, even though we may, as solo and small firm practitioners, be benefiting to some degree from the downturn in the economy, in that people who want to pursue appeals and other litigation matters might be more inclined than ever to look to solos and small firms. The cost factor is still going to be huge in terms of how whether the client decides to pursue an appeal. And so the answer to this question is really, as it is in most questions with the law, is it depends. In an appeal particularly, it depends on things like the nature of the case, the fee structure that would be involved, the lawyer's experience in pursuing appellate matters, and along with that goes efficiency and how efficient the lawyer is in pursuing appellate matters, and whether they have staff or other folks who can help them in prosecuting the appeal and handling some of the mechanics of the appeal. Fee structures, appeals can be handled on any kind of fee structure imaginable. Hourly rate, of course, has been the traditional way of handling an appeal. That is, sort of changing if you follow these things, and if you certainly follow some of the classes at Solo Practice University, I believe you'll see that there is a trend nowadays toward alternative fee structures, or even say blended fee structures, where you've got part of it based on an hourly rate and part of it on a flat fee, or part of it on a contingency fee. A contingency fee might be appropriate in certain circumstances. Generally, I would advise appellate lawyers to limit the circumstances under which they would accept contingency fee agreements to situations in which you're defending a judgment that's already been obtained, that's collectible, that's bonded, or there's been some other sort of security posted for it, just to protect yourself and protect your investment of your time, and if you're fronting costs, the investment of your money in handling an appeal for someone. So, the fee agreement, the fee structure is really a little beyond the scope of what I intended to talk about today, but nevertheless it is an initial consideration in handling the appeal, and it does directly affect the client's bottom line for cost, which, as I say, is almost always going to be the first question, no matter how much they believe in their case or in their appeal. So other factors in terms of the cost are, as I suggested earlier, who's doing the work. If you have a paralegal that you can charge a lower hourly rate, especially one who's experienced in dealing with the clerk's office, dealing with the court reporters, putting together some of the initial paperwork that's required, such as the notice of appeal, which we'll talk about later, record requests, and so on, it can really cut down on the expense of the initial phases of the appeal, a lot of which are sort of mundane, not really rote. They do require some thought, but if you have someone who's done this a few times, it can help in terms of managing costs up front. Also, if you're fortunate enough to have other lawyers working with you at lower billing rates, or who you delegate work to, whether that be an associate or a contract lawyer or some other arrangement, sometimes the work can be, to use the big law firm analogy, sometimes the work can be pushed down to where the client gets a more favorable billing rate. However, as I was suggesting earlier, sometimes, as this next bullet points out in the slide, with experience comes efficiency, and you learn the more appeals you handle, the more experience you get, the faster you're able to identify what are legitimate appellate issues and what are good points and what are not good points to raise. And that translates into the bottom line as well, because unfortunately, lawyers just starting out in appellate practice, it might take them, as in any other practice area, it might take them longer to get up to speed on certain issues. They may not be familiar with certain procedural questions that arise in an appeal, and so you have to weigh the pros and cons of billing that time or charging for that to the client. A lot of times the client, especially the more sophisticated clients, are going to expect you to know how to do certain things already. And so it just, again, comes down to case-by-case analysis. And so what I always suggest to people, and what I do in my own practice, in terms of when trying to estimate costs for a client, is to give a range. Again, depending on the fee structure. Obviously, if you have agreed to a flat fee, and I would suggest that you evaluate that very carefully, and experience helps greatly in evaluating flat fee structures. You don't have to give a range if you agree upon a set price. And clients are finding flat fees to be more attractive because they wind up giving more predictability to the bottom line and so forth. So you're likely to find that certainly business clients, small business clients, maybe even law firm clients, trial lawyers, are agreeable to flat fee type structures. But outside of that, or outside of the contingency fee structure, it's generally a good idea, particularly if the client asks this question, how much is it going to cost, to evaluate the case and to give them a range of what you think it's going to cost, not only in terms of predictability for the client's purposes, but also in terms of what you expect to bill and what you expect to collect in the matter. And then, of course, if your range is accurate, then when it comes time to settle up with the client, in theory, they don't have any surprises, and so there shouldn't be really any significant question about your bill, provided that you abide by certain good billing practices, in your practice generally, and those of course are beyond the scope of this lecture. So, if you can, I would suggest protecting yourself, getting as substantial a retainer as possible is within the client's tolerance. One of the things about appellate practice is within a certain month, if your billing cycle is monthly, you can pretty easily burn through a retainer, even if it's a considerable retainer. If you're writing an appellate's brief, for example, it's not difficult to spend 40 hours or more, even on the simplest case, in writing and preparing an appellate's brief. And so, if you're charging $250 an hour and you have a $10,000 retainer, writing one appellate's brief foreseeably could burn through the whole retainer. Retainers are, again, another issue that is outside the scope of, mostly outside the scope of what we're talking about today. But my point is basically, when you put together the fee structure, it's a good idea, in terms of setting client expectations, to provide a range of what you think the appeal is going to cost in an evaluation, and also to go ahead and get as much money as you reasonably can up front, so that you don't put a lot of time and effort into the case and risk too much not getting paid for it. So what's the second question that the client's likely to ask? The next slide gets into this area, likelihood of success, and the second question almost inevitably is, what are my chances on appeal? I've mentioned earlier already in today's discussion the idea of a written evaluation or evaluation, and that can be a very useful tool for setting the client's expectations in a number of different ways. And I'm getting into that in some of these bullet points. Basically, one thing that you can do, a sort of creative structure that I've used in my own practice and other people have used that I know of in their appellate practices, is to set up the matter to be handled in phases. And the first phase of which would be the evaluation. You could either charge on an hourly basis or a flat rate basis, or some other basis for just an initial workup to assess the relative strengths and weaknesses of the case. And we'll get into some of what those issues are in just a moment. And then secondly, the second phase of the appeal would be to actually, or the engagement would be to actually handle the appeal. And it's pretty easy to split those up. If it's a case that you're not familiar with, that you haven't worked on up until the point where you're getting ready to be engaged as an appellate lawyer to possibly handle an appeal. If a client seems somewhat hesitant, if they are, this is where it all sort of dovetails together. If the client is sort of hesitant based on the cost factors to hire you, when you tell them that an appeal could easily cost $25,000 or $30,000, which is something that, again, we're getting into assessing ranges here. I'm just pulling those numbers out of thin air. A client might find it useful and might be attracted to the idea that, hey, for $5,000, I'm going to review the record, and that's, again, I'm just pulling a number out of thin air. But for that amount of money, I will review the record for you, or I'll cap my fee maybe at that level, and I'll give you an assessment of what I think the issues are after talking with trial counsel and looking at the pleadings and looking at however much of the record is available, and then I'll write it up in an evaluation for you in a letter, provide it to you, and then at that point you make the decision on whether or not to appeal. And that has been, I have found, a pretty useful tool for, number one, getting the client to engage you if you offer this up, because they're going to be, even if they're cost sensitive, they're going to be more inclined probably to spend what's no doubt a smaller amount of money to get an evaluation of their chances. And so that's a useful tool. It also allows both the lawyer and the client a really good out. If the workup winds up being unfavorable, the engagement just ends. If the client and the lawyer agree, the engagement, perhaps including in your engagement letter that, if after reviewing the merits you have the right to withdraw, if your engagement to handle the appeal is conditional upon pursuing this evaluation and making a recommendation to the client, and the client's acceptance of that recommendation, it can be a good way of setting things up, and I would recommend considering that in appropriate cases. So what are some of the factors to use in evaluating what the chances are that the client is going to succeed on appeal? Well, first of all, and I think most importantly, is the standard of review that's going to be applied. If you have an abuse of discretion standard of review, say for example, the real issue in the case you think is likely going to be whether some prejudicial evidence was offered incorrectly, and the trial court committed error by allowing this evidence to be admitted. In a lot of jurisdictions, the standard for reviewing that decision is going to be abuse of discretion, which is inevitably a very, very hard standard to overcome on appeal. And so if your only issue that you identify in terms of prospective error on appeal is going to be reviewed under the abuse of discretion standard, then your chances of success are probably less, no doubt less, than if your standard of review was, say, de novo, where the Court of Appeals was going to actually review and give no deference at all to the trial court's decision. Usually that involves legal questions rather than factual questions. So, I think probably what you have to do is start out and looking at two issues, really, two questions. One, what are the likely appellate issues going to be? And then secondly, for those appellate issues, what are the standards of review that are going to apply on appeal? And once you have pursued that level of analysis, I think you have a pretty good assessment of what the case is about, what you're going to be bringing forward, probably in terms of prospective error, or if you're an appellee, how you're going to defend against certain errors, potential errors that you may have identified in the record. And then from there you can analyze the real prospects for success. And it helps. We have a really nice law review article that was written by some folks in Houston that actually looks at statistics for reversal based on the category of case, breach of contract, tort, personal injury as a subset of tort. Just any kind of subject matter within sort of a broad, painting with broad strokes, takes those subject matters and looks at all the courts of appeals in Texas, and then analyzes on a purely statistical basis what the prospects or what the reversal rates were, I guess is probably a better way of putting it, in those cases. And that is actually quite a useful tool in terms of providing a client with an evaluation, because what I'm able to point to, and a number of other Texas lawyers do this too, what they're able to point to is hard statistics that say, look, Mr. Client, if you've got a breach of contract case, the reversal rate in the 15th Court of Appeals, which there's not such a thing in Texas, is 25%. And so our assessment of your case considers that 25% reversal rate in addition to whatever the specific issues are with respect to the breach of contract issue, and you can gauge whether you think the case is a relatively strong one or not, and then provide a client a range of comparing their case to the statistical case of 25%, and say, I believe your case has a better chance than 25% being the average reversal rate for breach of contract cases. And so I would assess your prospects for success at a range of, say, 25 to 40%. And I would probably give a range that's about that broad, because one of the things that we've probably all learned by now is it's very difficult to predict what courts are going to do, even in cases where you might think otherwise. And appellate courts are no different. Judges are human, and even if a situation is, in your view, a laydown, it's really not. There are other factors that can come into play and might influence the judge's terms of the decision whether to affirm or reverse a decision. So the safe play, I think, in every case when evaluating the prospects for appeal or the chances of succeeding on appeal and costs is to provide the client with the range so that later the client can't come back and say, well, Mr. So-and-so or Ms. So-and-so told me it was a slam dunk and I was going to win my appeal. You have in your engagement letter or an evaluation in writing an assessment of this is what I think it's going to come in at, this is what I think your chances are. We have no way of knowing for certain how the issues are going to be resolved by the Court of Appeals and so forth. So, all right. Well, there are other issues too that you have to consider in advising the client whether to appeal. And some of them involve ethical issues and some are just practical. The ethical concern, namely, is that you have to have a good faith basis for pursuing an appeal. In federal court, you have, and certainly in district courts, Rule 13. There's an equivalent, more or less equivalent rule under the federal rules of appellate procedure. In state court, generally, the codes of professional responsibility are going to be a measuring stick by which we would gauge whether an appeal is meritorious or frivolous. And those are sort of loaded terms, but we'll come to some more detail on that in a moment. But the bottom line is, if in evaluating the client's chances of prevailing on appeal, you either don't identify issues that have any chance for success, or you determine for some other reason that the issues that are being raised are not valid issues, then that's something that you've got to bring the client's attention to, because you have to at least be able to argue, as we see here in the next slide. You have to at least be able to argue for the good faith modification or extension of existing law. And if you can't do that, the client might be looking at sanctions for a frivolous appeal. You, as the lawyer, may be looking at sanctions for a frivolous appeal. And with the way lawsuits are and matters getting tighter and tighter in terms of prospects for litigation and recovery, motions for sanctions, I think, are not uncommon in this day and age. And so that is certainly something that ought to be part of your analysis in terms of whether this is a meritorious or a good faith argument. If it's not a good faith argument under existing law, then can you at least argue that the law is wrong and the certain case ought to be reversed or overruled? And then if it were overruled, you would prevail. You're getting into a pretty dangerous area even there, and it might be useful if you have a mentor to talk through these issues with. It would probably be a good idea if you're analyzing a case like that to talk through what you're doing with someone else and get another person's input, just to be objective, because if you only listen to the client generally is going to be biased, and so your job as a lawyer is to give them a solid and realistic evaluation of their chances, and that would include, if you're really on the edge, what are the chances that there's going to be a finding that this is a frivolous appeal. And so when you reach that situation, sometimes you have to advise the client not to pursue an appeal, even if the client is the one who comes to you and says, I would like to appeal this judgment. I mean, the most obvious reason for reaching that conclusion and making that recommendation is that, as we see in the slide here, that the appeal would be frivolous or considered frivolous. Another reason, and this is just winds up being a cost-benefit analysis, is that the prospects for success on the appeal are low compared to the cost. If you have a $100,000 judgment, that's probably too high. Let's say if you have a $50,000 judgment in a complex case where the cost of the appeal is going to be, you estimate, between $25,000 and $40,000, and the client may just decide it's not important enough. Getting closure on the appeal and paying the judgment might be a better solution than actually continuing to pay to fight. it's good in some ways when you have a client who wants to stand on principle, but principle, as I tell people, can be quite expensive. And sometimes you have to just tell the client straight out, look, I think this is going to cost you to pursue this case. I think it's going to cost you practically as much as it's going to take to resolve it. Maybe even if you can negotiate, if you're on the defense side of a judgment, or if you're trying to overturn a money judgment, if you can negotiate some discount on the judgment amount, you might really be able to do a good service for the client by telling them, look, I think we can negotiate a deal here that will get you out of this for probably something approximating what you would have to pay for just the appeal, for attorney's fees and so forth. Obviously, if you've got larger judgments that you're dealing with, or more significant issues for one reason or another, that analysis is not going to hold true. And so it's just something to think about in general if, again, performing sort of a cost-benefit analysis for the client's benefit. And then finally, as far as reasons why you might advise a client not to pursue the appeal, if you get into certain niche practice areas like medical malpractice, legal malpractice, or if you get into certain industries that your client is involved in, insurance is one that comes to mind, there's a possibility that you might have a case that the outcome would be bad if you lost, not only for your client, but also for other people in that industry. So, for example, if you've got a causation issue in a medical malpractice case that has never been addressed before, and it maybe is a novel issue, you have to gauge the possibility and this is a delicate balancing act, but you have to gauge the possibility that a bad outcome is going to have a broad effect on a lot more people. Now, I say that reminding everyone that their obligation is to represent their client and pursue that client's interests within the bounds of ethics. But sometimes this can be the possibility of making bad law that would have a broader impact on just the client can be a consideration. And that's just one more thing to consider. So all in all, in terms of ethics and these other issues, I think just a good rule of thumb to apply is using good judgment and putting your client's interest ahead of your own, which is what you're expected to do as a lawyer anyway. Apply those basic principles to evaluating an appeal. Keep the client's best interest in mind, and I think the result will follow from that. So, all right, we've covered the issues of helping the client to decide whether to appeal. And we've talked about cost and likelihood of success are two major factors in some of the other issues that you might consider in working with the client on making that decision. And now I'd like to move into matters that are preliminary to the appeal. And there are several factors or several sort of initial stages, initial analyses that would have to be gone through in terms of the initial mechanics of an appeal. And so if you move to the slide that says preliminary matters, and I've described it that way, the mechanics of what must be done before you actually get to the point of writing a brief. And so the first issue that I wanted to address was jurisdictional issues. And so in terms of, as you get ready, once the client has said, yes, I want to pursue this appeal, if you're the appellant, and of course all of that, the previous analysis that I went through really assumes that you're representing the appellant. If the other side is going to pursue an appeal, you really don't have a say as to whether they do or not. And so, that's actually not a bad position to be in as a lawyer representing a client with a case going up on appeal, because if the other side does pursue the appeal, they're going to need representation of some variety. And so, if you have specific questions about how the discussion that we've gone through so far today relates to an appellee as opposed to an appellant, just shoot me a quick message through the website, and I'll do my best to answer that. Jurisdictional issues. One of the first things you will need to do in looking at taking on an appeal, and again, pursuing this really from an appellant's side, is to determine which appellate court would be the one to hear your case. Now, in some jurisdictions, it's really a non-issue. Some states, for example, basically have one appellate court and one Supreme Court. We don't have that here in Texas. In fact, we have 14 different intermediate courts of appeals to cover the state, and so, and even some who have concurrent jurisdiction over certain counties. So it's important to, depending on your jurisdiction, to identify, based on what the trial court was, where the cases from that court are going to go on appeal. It could be as simple as being one county over. You could be in a completely different appellate district, depending on your jurisdiction. Again, that also may depend on the level of the original court. There are, for example, in bankruptcy court cases, the federal district court generally is going to get first crack at appellate review of a bankruptcy judge's decision, and there you need to be mindful of where those are going to go, and don't file an appeal and try to pursue it in the circuit court, and say the Fifth Circuit, when the right place to go is actually to pursue it in district court. So check the rules on cases like that, of course, and you may have state law or state jurisdictional equivalents. In some jurisdictions, for example, a justice court, what we would call a justice court, you may have the right to a trial de novo, really not even an appeal, but a trial de novo in county court. And so it's really important to know your jurisdiction, know the court that you'll be pursuing the appeal from, and know the court system and structure so that you can identify where the case is going to go. These are generally governed by statute. The jurisdiction questions are usually governed by statute. Sometimes it's nice, the resources that are available on the internet today. In fact, I've given some examples here in the slide where we've got a map of appellate districts that covers all 254 counties in Texas, which is very useful. And then at the same time, the Supreme Court has made available a list of counties by appellate court, and that's useful too, because you don't have to drive too far to get out to places that the county is something you've never really heard of or not heard much about, and get out in a rural area, and you don't have to go very far to get outside your appellate jurisdiction, depending, at least for Texas lawyers, depending on what direction you go in. You might think that a case from a court 2 counties over is going to go to your court that you practice in all the time. That may not be the case. So it's really important to figure out where the case is going to go. And that actually could play into your evaluation of a case. If you know a case is going to go to a certain court on appeal, and if that appellate court is stocked with reputable judges who decide cases based on the law and so forth, that's one thing to consider. If you're going to a different court and that court is stocked with judges who are known politicos and who decide cases strictly on whether the appellant is the plaintiff or the defendant, that's, in reality, that doesn't happen. It's perceived to be that way sometimes, but just even being able to identify the court's reputation and explaining that to the client, and explaining the backgrounds of the justices if it's a relatively small court, even going down to that level of detail, can be very useful to the client, and it emphasizes and highlights again the reasons why you need to understand your court system and know where your appeals are going to go. And then a second jurisdictional factor really is to confirm, once you've identified the appellate court to which your case is likely to go, confirm that court has jurisdiction over the specific proceeding that you're talking about taking up and pursuing appellate review of. For example, interlocutory orders. Depending on what state you're in, or if you're, federal would be different, but if you're in a given state and you have a statute that allows interlocutory appeals from certain kinds of orders, then that's going to be a factor, as opposed to if a particular order is not, it's a known interlocutory order, it's not a final judgment, and it's not subject to appeal based on some statutory authority, you're going to have a jurisdictional question there if you try to appeal something that's not given the statutory grant, and the Court of Appeals has not provided express jurisdiction over that order. On a related point, there are other ways of pursuing appellate review besides ordinary appeals. Statutory interlocutory appeals would be one way. A second way that's used a fair amount here in Texas is by mandamus. It's an original proceeding, it's a writ, and it's designed to present to the appellate court a review of a situation in which the court presiding over the case that actually issued the order has abused its discretion, and the person pursuing the writ has no adequate remedy at law. That's a specific animal, and it's got its own set of rules, but that may be one other way of pursuing appellate review of a certain kind of order. So it's one other process or proceeding to be mindful of in terms of the possibility of seeking appellate review. And then, of course, what we think of most of the time in terms of reviewable orders are final judgments. The federal terminology generally is final order. And those, for the most part, are going to be appealable. If you've got a judgment that disposes of all parties and claims, and your jurisdiction may have certain unique rules about, Mother Hubbard clauses, for example, the effect what those have. That's all relief requested. All other relief requested is hereby denied, something to that effect. You'd have to know the locality's specific rules on what makes a final judgment, but once a judgment is deemed to be final, certainly there's almost always an appeal as a matter of right, subject to certain statutory exceptions could exist, such as the amount of controversy that would be required for jurisdiction to attach in the appellate court. There are some requirements like that out there. There may be some limitations on subject matter, depending on the court system again, and that's one disadvantage that I have as I sit here trying to provide an instruction, teach a course on appellate practice and procedure, is there's so much variety based on jurisdiction. And so I would always encourage everyone, and I know I say this a lot, but I would encourage you to check your jurisdiction-specific rules on all of these issues, really in everything that I say, because there are exceptions to almost every rule based on the jurisdiction. So once you've determined that the order is going to be appealable through some process, and the court to which the order is going to be appealed to, again, I'm talking about strictly appellate proceedings, not mandamuses, because original proceedings have their own terminology, and I need to focus so as to be able to kind of unify my thought process and not worry too much about exceptions. I'm going to focus now on pursuing an appeal as a matter of right, whether it be through interlocutory or an interlocutory appeal authorized by statute or through a final judgment. Moving to the next slide, the notice of appeal is generally the instrument by which the appeal is perfected and jurisdiction attaches in the appellate court. It's really, really important to know what the rules are in your jurisdiction. I'm starting to sound like a broken record. As far as what has to go into filing a notice of appeal, what the contents are, whether there's any fee that goes along with it. Because if you get it wrong, and in some cases it can be jurisdictional, and if the Court of Appeals doesn't acquire jurisdiction within a certain allotted time, your client might be out of court, and that is not an arrangement or not a circumstance that you want to see happen as an appellate lawyer. So there probably are forms in your area, in your jurisdiction, that contain all the necessary elements that you can use as go-bys. If in doubt, it's probably a good idea to talk to other appellate lawyers who, or a mentor who most often are going to be willing to help you, because nobody wants to see a lawyer commit an error that causes there to be a jurisdictional problem with the case. And so that's something to be very, very careful about. There are, again, exceptions even aside from the notion of bringing an original proceeding or a mandamus. Some jurisdictions, and Texas used to do this, may treat an appeal bond as the actual perfecting instrument by which jurisdiction attaches. And so, again, I'm beating this like a drum, but check your rules to know whether it's a notice of appeal, an appeal bond, or what the instrument is by which the Court of Appeals acquires jurisdiction. In the next slide, I've got a sample notice of appeal. You've seen this one before if you followed the class, because I used it in my very first presentation. And it's got the elements, for example, that we require in Texas. You identify generally the judgment or order that's being appealed, the court that it's coming from, the cause number, and then the last element is that this appeal is taken to the Third Court of Appeals at Austin, Texas. Again, we have a lot of different courts of appeals in Texas, and so one of the things that the Texas rules require is for you to specifically identify the court that you are intending to appeal to. So that actually helps the district clerk as well, although for the most part, and again with exceptions, the cases out of every district clerk's office are going to go to the same place. All right, timetables. Yet another important issue. And I cannot emphasize enough the need for appellate lawyers to master, not only appreciate, as I say here in the slide, in the next slide, but master the appellate timetables in your jurisdiction and the effect that they have. For example, in Texas, after a final judgment is signed, that final judgment will become truly final in 30 days. So you have 30 days to take some action to either extend out the time within which it's necessary to file a notice of appeal, and that is possible based on certain kinds of motions that would be filed, or actually file your notice of appeal. So probably in your jurisdiction, someone has written a paper covering, not only, and you can just go read the rules or read some commentaries on the rules to really help you identify what these timetables are. You may even be so fortunate as to have someone has actually sat down and mapped out the timelines for you. But it's important to calculate the precise date that the notice of appeal is going to be due in terms of perfecting the appeal, and you need also to know exactly where it needs to be filed. A common error among trial lawyers and people who generally don't handle appeals is to file a notice of appeal in the appellate court. And our rules, the federal rules, a lot of other states' rules provide that these notices are to be filed in the trial court, district court, whatever the terminology is. So I think the courts have gotten over time more forgiving about that, and there might actually be a way of correcting that defect. But it's just one more thing that, if an experienced appellate practitioner will know where to file the notice of appeal. And if you make an error in doing that, it sends a message, and it's not generally one you want sent to the client and to your opposing counsel, that you don't know what you're doing. And so, I just cannot emphasize enough the need for any aspiring appellate lawyer to sit down and just read the rules of appellate procedure, if there's a separate set of rules, or to the extent your rules of civil procedure cover appellate matters. Read those rules and understand what they mean, and read a commentary that talks about them, and read a law review article that talks about them, because this is something that you just really can't afford to make an error in applying, especially the rules that are governing what you have to do to get jurisdiction to attach in a court of appeals, so that you don't have a jurisdictional problem. Another helpful thing to do is to project some of the other initial deadlines aside from just the deadline for filing a notice of appeal, particularly if those deadlines might be jurisdictional. Some states put the burden on counsel for getting the appellate record filed, and so that's one area that could be sort of treacherous if the rules require you to do that as the lawyer and you don't do it because you've failed to calendar it or you just flat missed the deadline for whatever reason. You could wind up creating a situation where your client's going to be out of court because of an error that you made. And it's again another area where you just can't afford to know the rules. There's just no possibility that you can know the rules too well. You really need to master them. And it's just a good idea generally at the initial stages of an appeal to kind of project out the due dates and understand, if for no other reason than workload balancing, know when your opponent's brief is going to be due so that you can project out when your brief is going to be due, and you see that you've got 3 briefs due in a very short period of time. You can allocate your workload as best you can and manage it to try and avoid conflicts. We're going to move on to the next slide now and talk a little about docketing. I mentioned earlier filing the notice of appeal in the appropriate court. Most often it's the trial court. Sometimes the trial courts will send the notice to the appellate court directly. Some rules require you as or the lawyer representing the appellant to send a copy of the notice of appeal to the Court of Appeals, most often with a docketing fee. Yet another issue to be mindful of is that there being a requirement a lot of times of paying a docketing fee, excuse me. But once that happens, once whoever it is that sends the notice of appeal to the Court of Appeals, most often the court will acknowledge that in a letter. The court will put together, the clerk's office will put together a letter that it will identify the case by the cause number it's been assigned in the appellate court, by the parties' names, and it will expressly acknowledge the docketing of the appeal. A lot of times it will contain some basic information about what the court's expectations are. The court follows the rules of appellate procedure, and that seems sort of obvious, but sometimes courts have local rules that sort of supersede the rules of appellate procedure, so it's something else to keep in mind. And that once you get that docketing letter, that the case has been properly docketed and that the matter is now up on appeal. And once the appeal's been perfected, jurisdiction attaches in the Court of Appeals. In most cases, you're not going to be dealing with the trial court or the district court any longer. You're going to be communicating directly with the clerk's office in the appellate court. And there are exceptions, of course, most notably if you've got to go back and deal with reviewing any kind of supersedious or bonding issues, securing a judgment against execution, or if you've got an interlocutory appeal or a mandamus, you might still be going through certain proceedings in the trial court. But in an appeal from a final judgment, most of the time you're going to be done with the trial court once you file a notice of appeal and you get that docketing letter. Another thing I want to emphasize here is communicating with the appellate clerk's office is something you ought to do freely. I find generally that most clerk's offices are pretty user-friendly when you get up to the appellate level. They want things to go smoothly. The judges generally try to have people there who are pretty customer service oriented. It may not always seem that way, but I think in my experience it's become more that way in the courts I practice in than it has been in recent years, and that's a really good development for appellate practitioners, even to the point where you develop a relationship with some of these folks, and they're really helpful in answering your questions. And so I would not hesitate, if you have a question about something going on in one of your cases, to call the clerk's office and just ask. I mean, generally they can't provide detailed information about what's going on in your case, but they generally can provide, answer sort of general questions about, what do you need to do to accomplish, getting the record in, or so forth. So don't hesitate to pick up the phone, call the clerk's office, because as I say here, the appellate clerk is your friend generally. Okay, the record. Moving to the next slide. What is the appellate record? Well, it seems kind of obvious that it's the record of what went on in the trial court. The terminology varies. I mean, over time we've called it a transcript. Now our terminology here in Texas is we have a clerk's record and reporter's record, and literally those are descriptive terms. The clerk's record is the volume of papers that are filed with the clerk and put together, certified, and sent up to the appellate court. The reporter's record is what might otherwise be called a transcript, and it's the actual transcript of the proceedings as they're taken in the trial court, and along with exhibits, generally, if you've got exhibits offered into evidence. Some courts just call it the record, and that's perfectly okay. But without, well, let me state it this way. The record is the only way that the appellate court sees into or sees what went on in the trial court. So it's as I state here in the third point, it's very important to ensure that the record is complete. If it's not complete, the Court of Appeals may not be able to decide an issue that you wanted to decide. Or worse yet, you might be subject to some presumptions that are unfavorable to the appellant. If the record's incomplete, the appellate court may not be able to decide issues on the merits. And if you're the appellant and it's a critical issue for your case, then that can really have a negative effect on the appeal and on the outcome potentially. Or worse yet, if the record's not complete, there might be presumptions that apply against the appellant for failure to bring up a complete record. And so the ways of ensuring that a record is complete, if you're an appellate lawyer who did not work on the case in the trial court, are to talk to the trial lawyers, review their pleadings files, the index. Most often they have a hard copy file with an index of pleadings in it. Take a look at that. Talk to them about which of those documents are important or not important, and then finally, and probably I think the best way, because there are errors that take place at every stage of this, a good fail-safe is to review the trial court clerk's docket sheet, which is usually kept with the papers in the court's jacket, because they log every document generally that comes in, and ordinarily you've got a complete list of documents that have been filed in the case. So if you do those three things initially, very early on in a case, you're probably going to get all the documents you need in the appellate record, and that's, as I said, that's sort of a critical thing. The next couple of slides, I've provided some demonstratives, some samples of what appellate records look like. The first two slides are of a clerk's record and a reporter's record in a Texas case that I'm involved in. They're not terribly remarkable in their face, but I want to just provide some context of what it is we're talking about here. The third slide, the one that starts out U.S. District Court, that's actually something I really was glad to see. This is a record that I received, an image from a record that I received from a federal district clerk, and this is the form in which the record was sent to the litigants and also to the Fifth Circuit Court of Appeals. I got this record completely in PDF form with the bookmarks that you see on the left-hand side already placed there. And this is something that I like to do in my practice anyway, is to take records like the ones from the previous slides, which came to me just in paper form, and convert them to PDFs, and then bookmark the PDFs by document. And there are plenty of other places at Solo Practice University that you can go and learn more about this, as far as the technology-related courses and so forth. But this was an example that I wanted to include specifically because it is what I think is what we're going to see more of in the future in terms of records coming to us as appellate lawyers in PDFs rather than in paper form. And then ideally, with them already being bookmarked like this one was, I couldn't have been more pleased when I got this one. It made it so easy on my end to handle it and deal with it. And on top of all that, I got it on it's kind of funny, I got it on a CD, which almost seems, even a CD almost seems outdated now, but at least I got it. It came to me in electronic form only. I had the choice of whether to print it or not. When I needed to share it with opposing counsel, I uploaded all the data to my computer, and I was able to share the CD with opposing counsel. It was inexpensive to ship it. It was just a great deal all the way around. And so I think this is something that we can look forward to more of as appellate courts move more and more to electronic filing, and will therefore have, as the federal courts generally have, federal district courts certainly. And so with more records being kept electronically, it'll make it easier and easier to deal with these appellate records that ordinarily would take up a lot of space in your file cabinet. So that's pretty much the presentation for today. As always, I would encourage you to call me during my office hours. Fridays generally at 10 a.m. Central Time. I'll try and answer any questions that you have, or if there's any specific issues. Obviously can't give you advice about a case beyond some hypotheticals probably, but happy to just chat about appellate practice generally and see what, if anything, I can do to help you as you pursue that option. And I certainly hope, if you're taking this course, I hope you're doing that. We do have the official study group, and I always encourage people to ask questions there as an official forum, or as a less formal forum. We have the Appellate Discussion Lounge, which are all three of, those are generally linked here, where if you're logged in to your SPU site, you'll go straight through to the official study group in the lounge. And so I want to encourage participation in those forums, and again, I will do my best to answer questions if I get them in time on the videos, so that it will make things a little more interesting. Not just me as a talking head, appearing on your screen. So next time for the fourth class, which will put us halfway through the course, we're going to talk about another aspect of handling an appeal, and that is preparing briefs. That's a two-part presentation. Part 1 will be class number 4, and Part 2 will be class number 5. And look forward to seeing you next time here at Solo Practice University.